said that Nnamdi Kanu and killed his broadcast was the thing that killed Gulag. He said yes. Did you arrest anybody? No. How do you arrive to this particular investigation? Are you aware that the chief security officer of Imo State has also said that the report available to him has established that IPOB has nothing to do with the killing of Gulag? It's political. And the video was played there in the court.
All right, it's been how many days now? Today, 6 days since your client, Nnamdi Kanu, was sentenced to life imprisonment. What was actually going through your mind and your immediate reaction when Justice Omotosho read out that judgment of life imprisonment on Nnamdi Kanu?
Well, I felt embarrassed in the sense that somebody have told me this is how the judgment will go, even while the trial was going on. So I said I thought that the person was joking. So, and as somebody, a member of the legal team and his consultant and his brother and somebody that is very close to him, people knew that I'm close to Nnamdi Kanu. And they were telling me this thing. Not only within this country, outside Nigeria. I thought that they were joking. When I travel for vacation, people, Nigerians in diaspora, told me this is how the judgment is going to be. That federal government is bent on convicting Nnamdi Kanu by all means. I thought that they were joking. So, but when the thing now played out, I was embarrassed that such a thing is coming from my own jurisdiction, where I'm coming from, as a member of, as a lawyer, and a member of a legal profession. So I felt embarrassed. But in the other way around, I also expected it based on what I had. But whichever that is the case, is the judgment of the courts. No matter how stupid a judgment will feel that it is, it must be obeyed. They have convicted him. In fact, of course, you know that Nnamdi Kanu has been persecuted before, which you know, journalists you know, that has been persecuted. He has suffered the highest injustice somebody can suffer in the whole world. You are aware. Because of Nnamdi Kanu, they have turned judiciary upside down. They have turned our criminal jurisprudence upside down. It is the case of Nnamdi Kanu that somebody was kidnapped from a foreign country back to Nigeria without following the law. And nobody said anything about it. It's the case of Nnamdi Kanu, where court of appeal, unanimous, I'm not talking about customary court, I'm not talking about area court, customary court of appeal, second to the highest court, gave an order after hearing the judgment and discharged Nnamdi Kanu, and they ordered that on no condition should anybody try him because of the extraordinary rendition. Federal government look at court of appeal. Court of appeal, you are talking rubbish. We cannot obey it. And they never obeyed it. They kept on asking Nnamdi Kanu. We succeeded in making noise in pages of newspaper and in media houses, and they never obeyed it. Rather, they now use what we call a state of execution that is applied in civil matter. They now use it to stay that execution after 8 days. They were with him after 8 days in a country that is running democracy, in a country that is operating rule of law. Now they now met the second court of appeal. That court of appeal that said obey, release him. The court of appeal did not say, are you still with this man? The man that will ask you to release, you are still with him. The same court of appeal accepted that. The state accepted that particular state of a procedure and said the proceedings and went to Supreme Court. Guess what happened in Supreme Court? Supreme Court now look at all the whole issues. No, yes, it's true. The way Nnamdi Kanu was brought in this country was wrong. Yes, Nnamdi Kanu never jumped bail. The court ought not have revoked his bail. The court is even biased, written in black and white. The manner of federal government to use Operation Python dance to go and attack his house and demolish and kill several persons there and left with some corpse was wrong. Supreme Court mentioned all these things. Yes, we have also, from our own submission, we have also discovered that the charge upon one of the charges upon which Nnamdi Kanu is being charged was brought on a wrong law. Now, the only thing is that they should continue with the trial. Whatever objection you people have, the defendant, Nnamdi Kanu, whatever objection you people have, you can raise it at the court. But what do you call it? The prosecution go and amend that particular count charge to reflect in the correct law, so that the trial should continue. I don't know whether you're going to say these are the orders of the Court of Appeal. Do you know what they did? The federal government only choose only one. Do you know the one they choose? The one of continuing with the trial. They refused to amend the law. So when we get to that place, based on what the Supreme Court said, say, my Lord, you can see what the Supreme Court said. Look at the judgment. Look at if they even accuse you that you are biased. Can you allow another judge to look at it? Binta Nyako, Nnamdi just Binta Nyako on her own, consider the application and they disqualified herself by an order and send the file back to CJ for CJ to reassign. So CJ now, administratively, through administrative letter, ask Nnamdi just Binta Nyako to continue. When the file now get back to that, and get back to Binta Nyako's court, and Nnamdi Kanu was brought to the court. Nnamdi said, my Lord, no. You have already, there is an order, substituting order, disqualifying yourself, recusing yourself. That order is still subsisting. That order cannot be set aside by the administrative letter by the CJ. Please, you stand recused yourself. So I think they saw reason with him, and the file was taken back to CJ, and it was reassigned to Honorable Justice Omotosho. So when a matter gets to another court, is to start what we call afresh. In law, we call it de novo, starting afresh. Whatever thing that happened in that old court is a nullity. Now, Nnamdi Kanu now took a fresh plea. I want you to understand it. Nnamdi Kanu took a fresh plea. What do you mean? A plea, guilty or not guilty? Remember that he has taken his plea in that of Honorable Justice Binta Nyako, and it was based on that plea, that proceedings, pending proceedings that was going on. I don't know whether you're getting what I'm saying. That was why Supreme Court said let the matter continue in that court, because Supreme Court was having in mind that the matter will continue in that court. Supreme Court never advised their mind that this matter can be assigned to another court and it will start afresh. I'm heading to somewhere. Do you know where I'm heading to? Repealed law. I'm coming. Repealed law. Now, when the Nnamdi Kanu took a fresh plea, everything now started de novo, afresh. The proceedings which Supreme Court made reference to in Binta Nyako's court has gone with sponged with whatever thing that happened in Binta Nyako's court. Now we are now in Honorable Justice Omotosho's court. One expected them to amend that particular count 7. That was count 15 before Binta Nyako. Now after the Binta Nyako struck out that, it becomes count 7, which they brought in under on the wrong law. They refused to amend it. They know the implication of amending it. They allowed it. Now that one is on that. I don't want to go what happened, how Nnamdi Kanu was brought to this country. I don't want to go discuss about how the Operation Partners attacked his house, how he never jumped back, how he ran away. I don't want to go into that. Now let's go back to where we are. Honorable Justice Omotosho. So when we came, the matter started. After his plea, we continued. So they opened their defense. Now the defense, the witnesses they called 5 witnesses, all DSSS officers. Now, out of the 5, Nnamdi Kanu said, out of all these people you called, it's only one person, you, that investigated me, that arrested me when I from Lagos to Abuja here, that even interviewed me. I didn't know these persons. I never met them. So Nnamdi Kanu was alleging that all those people were rented witnesses. That was his allegation. Now, how do I believe Nnamdi Kanu? All the questions they asked them, I don't know. You said that Nnamdi Kanu killed his broadcast was the thing that killed Gulag. He said yes. Did you arrest anybody? No. How do you arrive to this particular investigation? Are you aware that the Chief Security Officer of Imo State has also said that the report available to him has established that IPOB has nothing to do with the killing of Gulag? It's political. And the video was played there in the court. Now, going by the statement, Nnamdi Kanu made a statement in his statement, because in any criminal trial, investigation has to do with statement of the accused and his interrogation. It's his statement that will lead you to investigation, and you write an investigation report. Those people, they never write any investigation report. But that one is by the way. Now, the judge now, when they showed Nnamdi Kanu said, yes, I made this statement, but my lawyer was not there. I made it under duress. There was what we call trial within trial was conducted. For those of them who said that Nnamdi Kanu never made any statement, because they are not following the trial. During that trial, within trial, Nnamdi Kanu used that opportunity to explain everything about IPOB, and he was cross-examined. Nnamdi Kanu was cross-examined within that trial, within trial. It is there in the court record, and the court is expected to take the judicial notice of that. Is a state witness. That is statement he made from the dock and the cross-examination. So after that, the judge was convinced that Nnamdi Kanu was made that statement under duress. He made a ruling and he rejected that statement of Nnamdi Kanu, and the market rejected. Now, the question there is that now that the statement has been made, market rejected, which means Nnamdi Kanu has no statement. On what basis did you prefer the charge? Because you can't put something on nothing expected to her to stand. Even the judge, on his own, raised the biro in the court, and the biro fall. He raised it again, said, "Do you know me? You can't place something on nothing expected to stand." That is the beginning and the end of that trial. Because that charge was predicated on that statement. And they asked them, Kalagabi SAN. I think it was Kalagabi that. Anyway, 3 of them were cross-examined. Kalagabi was cross-examined, Meketaba cross-examined, conducted the trial, Eroko conducted the trial, as they were exchanging all those learners. And then one of them asked, you can't ask this investigation. Was there any investigation report? He said no. That one is on that. That one is on that. Now that one has gone. Now, during the trial, when the trial was going on, I want you people to just listen so that those who are arguing what they are arguing in social media who understand where Nnamdi Kanu was coming from. During the trial, at the commencement of the trial, the judge said in the record of proceedings, "I am not going to entertain any objection of admissibility of any exhibit. Any objection that has to do with the admissibility of any exhibit that has been tendered, please reserve it, and you can address it during your final written address on record." Maybe he forgot that he said such a thing. So if they want to tender that exhibit, those doctored exhibits, you know what they did? Any place Nnamdi Kanu said, if this can happen, something like, let me just use instance, and said, any police officer who used the gun government gave him to protect life and property, and he wants to use that gun to kill you, collect it back. Collect it before he kill you. Collect it and use it and kill him first. Self-defense is a self-defense, and it's also admissible in law. Now, they will now remove that one, and they will only copy from only that one. He said, key police officer, and they'll attach it and play it. And if you watch all those exhibits, thank God that it's a public record if they will release it. If you watch it, thank God that most of you are experts in this field. You will know that it's cut and joined. And any time they want to tender it, you see Nnamdi Kanu in the witness box, he will be in the dock, he will be shaking his head. He say, "My lord, we will object to it, but we will reserve our grounds of objection during final written address." This is how all of them have been tendered. I don't know whether you get what I'm saying. So when they concluded their trial, I think they closed their case. The prosecution closed their case. I think Kalagabi jokingly told that one. So this is what all these things you tendered. That's what you now used to keep this man for 3 years in the name of terrorism. This singlet, boxers, all this tape. That's what we want to use. So they jokingly, I ended up saying, I was there. So when I file our no case submission, I enjoined anybody. It's a public document. Go and read that no case submission. If you read that no case submission, that was where all these issues would have been ended. But in no case submission, my lord ruled that there's a prima facie case against Nnamdi Kanu that he should open his defense. Of course, there are some things that I will not tell you here. What brought about, just like the other I told you, I'm a lawyer, and you, Mr. Victor, you engage me to represent you, and you are not a lawyer. And there are some things that you need to know as a layman. That is to say that 1 + 1 is 2. And I have read it in your law book that 1 + 1 is 2. So in the practical, you now ask me, Mas, but you say 1 + 1 is 2. And the judge said that is not, that he won't admit it. What happened? Are you understand? Sure. I will tell you to just forget about it. A lot of issues will be coming up. His Nnamdi Kanu's trial is more political than legal. So a lot of issues we are coming up, which, as a lawyer, I am an officer in that temple of justice. And being an officer in the Temple of Justice, I'm expected to protect the interests of the court first. My duty first as a lawyer is to the court before my client. So a lot of issues came up. The long and short story that there was an understanding, and the lawyers had to leave. They have to leave.
Did they leave voluntarily, or Nnamdi Kanu asked them to step aside?
There was an understanding. They have to leave. There was another understanding. I have done it in several cases. I have done it in several cases for the guest where I'm representing a client, and it will be as if I'm having an altercation with the judge. I will tell the client, please, can you take your file to another lawyer? I don't think that I will continue with this matter. Because it will be uncalled for that I am having an altercation because of a case of a client. The APDC will not take it lightly with me. I don't know whether you get what I'm saying.